to the Layman's Law School, where three hillbilly lawyers get together and discuss the legal issues of the day and try to educate the public about some of the issues in the law. And specifically today, we're going to be covering a very common topic that happens quite a bit and that we deal with a lot of cases in. That's premises liability. So, gentlemen,
my favorite.
yes,
It's my favorite.
This is Reid's
my specialty.
Yeah,
just did a summary judgment hearing today on it. You know, that's why I don't have a Hawaiian shirt like yourself.
right.
I did loosen the tie, threw it away. You know, after I won and just destroyed the other side.
It's the perfect topic to have our resident expert, Reid
fresh out
Sanders.
of a hearing. So, there
Well,
you go.
good. Well, we're going to be talking about slips, trips, falls, how to keep your premises safe, and some of the more sort of obscure areas of the law. And we're actually going to be discussing some Latin issues. There are things in the law that, the law uses its own sort of language, and that's one of the first things you have to deal with when you go to law school is learning what all these silly words actually mean.
I took 2 years of Latin at Lakeside High School and remember every bit of it. So that's what has made me such a proficient attorney.
I don't know any Latin, but I can break it down. You know, to the layman.
I actually remember very little.
I was about to say I was going to put you through a little test because I know that this print that I put this stuff on is a little small for you,
right? He
right?
didn't have his readers.
But I actually did define some of the Latin terms here, and we'll see how that Lakeside education serves you here. Oh,
yeah.
Oh,
listen, I'm thirsty.
Okay.
Friday
afternoon. It's been a long day, long week, good week.
Yep.
Cheers.
Cheers.
This is a true classic Bud Light. This is a South Carolina version.
Okay, very nice. Shawn?
Oh, it's a spot.
Yeah,
Delicious.
punish me every week.
Punch you every week.
Oh, okay. It's my fault. I didn't bring anything, so
Yeah, there you go.
I deserve it. Well, to start out with, guys, it's just like on a basic level. What are the major sort of like elements for establishing a claim based on premise liability?
Well, the first thing that you all, well, you can do it two different ways. All right. So as a plaintiff's attorney, what we look for is, number one, you got to have damages. Right? If you don't have damages, premise liability is tough enough. It's kind of like medical malpractice. If you have a sprained ankle, it's too much work and too difficult to move forward. So you got to have significant injuries.
Sure.
The next thing you got to have is a hazard, and we can go into what a hazard is, but it has to be in there. There's a lot of fighting on what classifies a hazard, what isn't a hazard, blah blah blah. Then you have to have knowledge from the defendant, and that can be constructive knowledge or actual knowledge.
Knowledge of the hazard.
Of the hazard,
Right.
right? And it can be constructive knowledge. It should have known that there was a hazard there, and that we'll talk more about it. But it can be inspection. It can be at a household that you've gone over this area many times and should have seen it, should have fixed it, should have known. And that's tough to prove.
Sure.
Because you're proving something that somebody should have known. You know,
Right.
it's very difficult to show somebody what their mindset should be, that kind of thing. And this is where it gets tricky in premise liability. If something is so strong, if the hazard is so strong and so damning, even if the other side knows about it, then they're going to say, well, it was so bad, you should have known about it.
That's right.
So you have to keep, it's a balancing act between the hurt person, the plaintiff, what they should have known and what the person that injured them should have known.
Right.
So it's got to be in between.
Yeah.
And so and then lastly, obviously, which we always talk about is you got to have somebody who's able to pay for it. And those are really the if you want to start, that's it. Those are the elements.
And generally, when we're talking about that, we're talking about insurance.
Yes, insurance. And you know, when it's at a store, obviously they have insurance. But when it's at a house or if you come to my house, Shawn, and have a bad step and you fall, that's what homeowners insurance is. When you run into real problems is when you have somebody who's renting a house that doesn't have rental insurance. The renter should have known about the hazard, but the owner did not or should not have known. That's when you have problems because then there's nobody to be able to pay for it.
And then even in those cases, in a lot of these, places that, people are forced to live because of financial condition.
Right.
Maybe the owner doesn't even have any
Very true.
insurance.
Very true.
They're just renting out, these places to give people the opportunity to live there. Some people call them slumlords, and some of them are, and others are just, this is, I'm not putting any more money into this house.
Right.
I'm trying to provide you some type of affordable housing to keep you off the street.
Right.
This is the best I can do for you. So in those cases, a lot of times, once we do the research and investigation, that person doesn't have any type of homeowner's insurance on their rental property.
Yeah.
Yeah. And so, just to sort of recap the basic elements, number one, there has to be some sort of duty by the landowner, okay, to actually keep the place reasonably safe in a reasonably safe condition. And if there is a hazard, they have a duty to actually give notice of that hazard to people that are coming on their property. But there's also and to try and make the property as safe as possible for the people that are showing up there. But there's also this distinction in the law between what is called an invitee and a licensee.
That's where I was going next.
Yeah.
That's always a problem.
Okay, and so and not every state has this distinction. In California, there's no distinction between an invitee and a licensee, but there can in state of Georgia, South Carolina, you can have higher standards of what you're supposed to do in order to actually protect these individuals from your hazards on your property. And one of the highest ones, of course, is of the invitee, and that mostly applies to shop owners. Retail facilities are actually benefiting by you and they're encouraging you to come onto their land so that they can actually benefit from it.
Yeah. And on that same line, Chace, you said shops and things of that nature, but also it's homeowners. If you have somebody that you call to come fix your air conditioner, or you have somebody call it, come fix your roof or whatever. If you're calling for somebody to come do work for you, then you have to make sure that they're safe. More so than if I call Chace and say, hey, come over and have a beer with me. You're a licensee, and you're just a friend coming over. You're not. The only thing you're bringing is enjoyment of hanging out together. That's it. Yeah. So it has to be, essentially, it's like a contract. Basically, it has to be consideration and acceptance. And so, but not to cut you off, but it can certainly happen at the house, and people get confused about that. And there are times where and I've done a lot of cases where that is the fight: is it a licensee or an invitee? Because let's say, I have a buddy, Chad, who's a general contractor. If he comes over to the house, he's my friend. He's coming over to hang out, but we also have stuff that we might be working on. We might be fixing. He might be helping me fix something. Is he an invitee?
Probably the golf cart.
Probably the golf cart, But you know what I mean? So that's where it gets gray, and that's where you have arguments of the fact. And that's where, like today when I had a summary judgment motion, you don't argue facts at summary judgment motions. You argue the law. So.
Correct. and they use those to try and, weasel their way out any way possible.
Exactly.
And avoid, having to pay for damages that they owe.
Right.
Yeah. And so the list, I guess, would be of kind of invitees would be like your people coming in to shop at your grocery store, people like you say you call to come over, a roofer coming over to work on your house or something like that, or a delivery person, you're ordering food and they come up your stairs, and those stairs they're not supposed to come up the back stairs because those are rotten,
right? And
that's the only way to get to the back door. He pulls up, goes around there and falls, and you didn't warn him, didn't cordon it off or whatever, anything like that. That's an invitee being hurt at your home, especially if you don't try to fix it. If you don't properly sufficiently warn people of the hazard, you're going to be held responsible.
I'll tell you one more instance that goes back to a store that is a fight between what is a licensee and an invitee. And I've had this case, and so essentially there was a lady that was selling things and had asked the store if she could be out front, and had a tent and was selling things.
Girl Scout
cookies, things like that. Well, she went into the store to go use the restroom and had a fall, and it was definitely the store's fault, but she was a licensee because she wasn't going in there for the benefit of the store. She was going in there as a licensee because she was not. She was just going in there for the benefit of herself.
Sure.
And she wasn't shopping. She wasn't looking around. So, and that became the focal point of the issue on that case. So you can have it both ways. You can have a licensee or an invitee at your home, and a store can have a person that is a licensee or an invitee there. So that's it seems like a small distinction, but it can be absolutely crucial to the case of what you are classified as.
Right.
And the reason we bring that, that distinction up is just because there's a different standard of care that applies. There's a different theory of legal liability that we have to prove in a case.
Right.
With invitees, the standard is much higher. This is, the shop owners and homeowners, if they have somebody coming to do business, have to live to a much higher standard than if a person is just visiting your house who's a friend of you and is a licensee. That's really the distinction, and that's where the fight in these cases is often at.
Yeah. If I could, I'm going to ask Genuine to actually bring up some video of an actual situation like this with an invitee, and there's an issue as to whether or not this person, whether the store had any sort of knowledge of the hazard.
Right.
But what we have here is a person that's pulling ice out, and if you look, she's already picked the ice up, and now there's a black mat there, but she's already set it down on the ground there, and now she's walking out of the store with the ice bag. Well, what do we know about ice?
Condensation.
And that it melts.
Yeah.
And it puts actual liquid on the floor.
Let me watch.
And here we go. We have our patron. And boom. All right, what do we see here? What are the issues?
If you're looking at it to have a claim, like we would, we're plaintiff's attorneys.
Sure.
You want to see where the workers are and what are they looking at.
Right.
And do they have a responsibility to keep watch of that area? The first thing that I already see that looks good for the defense is that there's a mat there. And so that's going to soak up some of the water because they know that it's potentially when you're opening and getting the bags out, you're going to put them on the ground.
Right.
And so that's already showing that they're making an effort.
Right.
The second thing is timing. And so you see that the employees are around, but it happens, the fall happened so quickly after the water was there. Here's where people mistake. You still have a claim. You have a claim, but you have a claim against the lady who took the ice out.
Yeah.
And so you can't sue you can sue the store, but you're going to lose because the store didn't have time to fix the hazard. They didn't have constructive or actual knowledge. They definitely didn't have actual knowledge because you could see the employees weren't looking that direction. They were busy working and the baggage or whatever they were doing, but they weren't looking at it. Now, if the video showed an employer looking at it, then I don't care about how much time went by. They saw it. Then they had actual knowledge of it. You have to prove constructive knowledge. They should have known about something, and that takes time.
Yeah.
And so that goes into the inspection process. Now, there's not a hard and fast line on the amount of minutes, but we do know in the state of Georgia from the Supreme Court of Georgia that it can be at minimum 15 minutes. So it might be lower than that. There hadn't been a case but we know a case that it had only been 15 minutes that the Supreme Court upheld that it was a hazard that the store should have fixed. This one, you're talking 10, 15 seconds. There's just no way, in my opinion, that the person who fell is going to be able to hold the store responsible.
Well, in doing a comprehensive investigation on something like this, through the discovery process, we're going to request some video footage that goes back in time.
Sure.
Because, that's a little bit of a distance away from where the actual ice machine was.
Absolutely.
By watching this little video clip, we're assuming that ice was the cause of the leaking and the person slipped on that. But, sometimes you can go back, get video that goes back an hour and see that, so-and-so dropped a pickle jar right there.
Right.
An employee came over there and helped them with it and then left the area. That's where you show that they had actual knowledge of the spill. When we only look at a 20-second, 30-second video clip, we don't have all the information, and we want to at least check the box and say, okay, so this didn't happen. To the best of our knowledge, it didn't happen. And the employees didn't have actual notice or should have had constructive notice.
Right. Sorry, Chace, another thing that on his point that you look at, you back it up, and I talked about the mat being helpful.
Mm-hmm.
If you look back and over time, if you see that the mat is getting just wet, drenched over and over and over and over again, and then just because other people walked through that area and didn't fall, it may have started, or there may have been a leak there that they didn't clean up. They put a mat down, the mat stays wet, people walk on it, create this hazard over time, and then the person falls. Then you have a case. But like you said, from what we have on the clip, doesn't look like it, because causation of the hazard, from our opinion on the video, was from the ice. But it if you back it up, it may have come from somewhere else.
Right. Yeah, and it's important that is that video clip is used, or I'm using it today to try to show the difference between, or to highlight the requirement of knowledge by the business. If a hazard happens very, very quickly, and then somebody gets hurt right after that in that hazard, the business had no reasonable opportunity to know about it,
right,
and then do something about it, right? Well, the important distinction, you guys have said it a bunch, actual knowledge versus constructive knowledge. Actual knowledge is there was an employee that was there that did see it, that maybe even went over and examined it and went to go get a mop bucket, and you could see that on the screen. That is actual knowledge of the issue. Okay, when it comes to constructive knowledge, it basically means that all the facts and circumstances around that hazard means that the business should have known about that issue. In other words, they had a busy time during that time. They put the mat out. That shows that they know that there's an issue with water coming out when they pull the ice out, and they know that 20 people have fallen in the last 3 years at that particular place, specifically from the ice that comes in the water that drips off, right? Well, those circumstances should let you know that that's a place where people are going to get hurt if water continues to drop. And now they made some efforts to fix it by putting the mat out there, right? But is that sufficient? A jury would also get to decide that if those other facts are in place. And that's one of the things that a lawyer can actually really sort of help in, is being able to do a proper investigation of like past claims that are surrounding a particular hazard like that. I don't know if you guys noticed, but there's a lot of convenience stores out there that have their ice machine outside.
Absolutely.
It's outside the store. Why? Because there's concrete out there. That stuff, the water gets dissipated into the ground. You don't have the sort of slip surface you have in the store, and so that's a way in which they actually protect themselves quite a bit. But that video is about constructive knowledge. And Reid, you were just talking about this issue of when a hazard is so obvious, okay, that
well, you get into the next one. I've said it, and I know I've said it, but I want to make it clear because I hear this a lot. It's not my fault that I fell, and I agree with you. And you still do have a claim, and you still do have somebody responsible. It's just not somebody who can pay for it.
That's right.
Well, and I guess where I battle with things the most is, where does the constructive knowledge come? Where does it actually occur? You said that we have Supreme Court cases that say XYZ,
right?
But where is the duty to inspect by, especially like retail places, and what? I mean, do they have to inspect the aisles of their store every hour? If they don't if an employee doesn't walk down that aisle for 6 hours, is that way too much? Things like that is what a lot of cases that I get come in. I'm battling with myself. Well, this happened in a particular location. What would I reasonably expect a shop owner or supermarket owner and their employees to do?
Well, some of that is going to be, some of it is case law, and some of it is the type of business, and then also the biggest one is what are the policies and procedures of that store. And so when you get into litigation, there's something called 30B6 witnesses. And 30B6 witnesses, as y'all know, are a representative of the store who's supposed to know about certain topics that we give them. And one of the topics we give them is, what are the policies for cleaning? What are the policies for keeping a lookout? How many employees are supposed to be here on busy schedules? All this kind of stuff. And so that is one way. That's a major way to get constructive knowledge, is if you don't follow your own rules. If you set up a rule that says we want our employees to go down the hall, go down the aisle, every 15 minutes and they go down at every 30 minutes, that's a problem because you set the rule and you're breaking your own rule. So then that would be constructive knowledge. And then, like I said, it depends on the store, depends on how many employees, depends on the time of day. So all that is very fluid. But we, like I said, the minimum amount of time that we know of right now that can be successful is 15 minutes. A lot of times it's longer. It's an hour, it's 2 hours or whatever. But we know the shortest amount of time as of right now is 15.
Yeah. And one of the other things you can do is actually show that they didn't follow their procedures, that their procedures based on the number of people that actually came in there, like how busy the store is, what they're actually doing in that store. If all you sell is baby oil and you have like a marble floor, okay, you better be inspecting your floors like a lot, right? But you know, it can change based on the industry and what you're doing, and you know, they might have one customer in there per day. And if that's the case, then the inspection procedures are what's reasonable under those circumstances are going to change if you have 1,000 that come in every day. So that kind of thing weighs into what is reasonable under those actual circumstances. But one of the issues, again, is the constructive knowledge and how that's established. And I have printed out here some high court case summaries. And this is in law school, they teach you principles of law. You know, we've probably read this case, right? And they use the same cases over and over again, the same fact patterns in order to teach the principles. And this is Ortega versus Kmart. And Ortega slipped in a puddle of milk while shopping at Kmart and injured his knee. At the personal injury trial, he testified he did notice the puddle a little bit before he slipped, but could not determine how long it had existed there. He claimed that because Kmart had failed to reasonably inspect the area, that the jury could infer that the puddle had been there for a long time. Now, Kmart, before they inspected it, and that they should have seen it if they had done the inspections, right? Well, Kmart offered evidence that it trains all of its employees to clean up spills usually every 15 to 30 minutes. However, Kmart's former store manager, 30B6, conceded the fact that the puddle could have existed for up to 2 hours, right? Because they don't keep any records of inspection procedures. And the jury found in favor of the plaintiff that they should have had some sort of inspection procedure where they had these things and had these records and actually did the inspection. And because Kmart couldn't actually provide evidence that they had done the inspections that they themselves had determined were necessary every 15 to 30 minutes, because that's what's necessary in a grocery store, the court said that amounts to constructive knowledge on which a jury can base a verdict and infer that they basically had knowledge or should have had knowledge of that puddle. So
and another thing to make clear on that doesn't mean that you win. That means that you're allowed to have a jury decide it. And so the jury can still say, well, you know, the guy just said he saw it before he stepped in it. And, you know, and maybe he should have watched out. You know, the jury can do whatever they want to do. But this law is basically saying that it meets the elements to allow a jury to decide it. And that's the key to that is that constructive knowledge. Just because you have constructive knowledge, a jury can still say, well, he should have seen it. I mean, you know, he shouldn't have hurt himself. He should have, you know, whatever they want to do. Yeah. But you got to meet the elements to get it to that point.
And in this case, you know, you would think that a jury would say exactly what you said. He fully admitted that he saw it and stepped in it anyway and slipped. You know, so there's definitely a distinction between getting a case past summary judgment and actually getting a case to a jury, and what a jury of, you know, what we, you know, believe is going to be reasonable people are going to think about your claim.
Absolutely.
Yeah, and that brings up another point, the comparative negligence. Okay, for people out there, if you're making an actual premises liability claim, you have to remember that there are duties, okay, that you have to establish for the premises, the owner, that they had a duty to inspect their property, to keep it safe, to eliminate hazards. But you also, as a reasonable human being, have a duty to watch where you're going. You can't just go around a grocery store and put a blindfold on and then sue somebody when you step in something or trip over something. You have to use reasonable, care.
This is why I love and hate premise liability, though, because I agree with you. You're 100% right. But there's always a but in premise liability. But if you're enticing someone to look somewhere, then it's not reasonable for them to look where they're walking. In a grocery store, they put the items strategically at eye level that they want to sell. They're enticing your eyes to not look at the floor. So if you're shopping and you're looking at the aisle, walking across and looking at, Cocoa Puffs versus Frosted Flakes, and you don't see the water on the ground where normally you'd be looking where you're walking, and you see the puddle on the ground, they're still going to be held responsible because they're distracting you. And then you also have optical illusions. That's another exception to the exception. So premise liability is fun but very frustrating in that it's always multi-layered.
Yeah.
It's a weird side of the law.
Yeah. Well, I'm going to bring up another clip now, if you could, Genuine, and this one would be the pit. So this is an example of an open and obvious hazard, and this is an example of where you might not be able to make a claim.
Oof, I will say this.
That's a rough fall.
You got to know your own limitations there, my friend.
Yep.
I mean, he's a big fella. Let's watch it. Well, let's roll that footage. Look, if you're gonna make that step, let's stretch it on out, my friend.
All right, and it looks like it's pretty obvious that the ground is wet. It looks like this might be someplace they're washing cars. They might be working on cars. There's oil on the ground, and it looks as if he looks to the other side of the pit and then chooses to decide to step across. He's going to go all the way across it.
Yeah.
Right.
He didn't slip into the hole.
No.
He slipped as he was trying to jump the hole.
Right.
And that's
right.
And so the hole is, to your point, the hole is a hazard, and it is a hazard for people. And I would bet to say that the only way to win this case is that there are rules that say do not let customers in this area. And they say, hey, buddy, come on back. Then you might have a chance.
Yeah.
Outside of that, you see the hole. You know that it's wet. You know that it's oily. You're trying to make a jump. I've done stupid things and hurt myself.
Right.
This guy just did that.
Stupid thing and hurt himself, yeah.
Absent the slip and the oil, I'm not sure that individual could have made it over that.
I don't think
pit.
he could have. He didn't look flexible enough. On solid
brush broomed concrete with traction shoes.
with a pole vault.
I thought he looked incredibly athletic. But, but yeah, that's an example of what they call assuming the risk.
And so that is what also is called an affirmative defense.
Yes.
So you still have all the elements that create a premise liability case. There's a duty. There's a hazard. There's a bad injury. They know that the store owner knows that there's a hazard there. So you win, right?
Yeah.
No, your affirmative defense kills it. And the affirmative defense here is that you assume the risk and you tried to jump over a hole and you didn't make it.
Right.
And in cases like this, there's so many defenses that, open and obvious, superior knowledge, things like that. I get calls, once a week at least, and talk to people that have been injured in some way. And, before some of those cases, before we even bring them into the office, I say, Miss Smith, I'm going to run by that place today and take a look at what you're explaining to me, to see whether or not I think that we have a claim that we can actually pursue.
Right.
And then, you go to this place and the entire, parking lot is just riddled with potholes, and it's basically concrete or asphalt that has turned into gravel.
Rubble, yeah.
And in those cases, we have to call the client back and just say, this uneven terrain is just so open and obvious to everyone that it's not going to be a case that we can probably pursue and probably get you any compensation for.
Yeah.
And the only true exception to that is, and it's rare. Don't get me wrong, it's rare. But you can have cases where it covers two different things. So if you traverse an area, if you go over an area that has a hazard, and you go over it every day of your life, you know, it's at your front door, whatever,
Right.
or your apartment complex, or whatever it is, or your favorite gas station, like me. You know, I'm a gas station kind of guy. If I
You're
know
a
the
gas
hazard-
station foodie.
Food kind of
Foodie,
guy.
yeah.
Not just a gas station guy.
Yeah.
It's part
gas
of the
station foodie.
It's part of the food group for
it
Reid.
is my only food group. But I know in my favorite gas station that there's a hole right in front of the door. I know that. I've been there, you know, a lot. Let's be honest. But so when you have situations like you're talking about, Shawn, where it's open and obvious in that video, or a situation that you've traversed a bunch of times, there's really one exception, in my opinion, and that is if you have no other way. And so if you're in a home or in a store and you know it's there, but that is the only way out. And I've had a case where there was a bunch of water on the floor at a store, and the lady had to go to the restroom, and she knew the water was going to be on the floor when she's coming out, but she's got to go out of the bathroom. And so when she went out of the bathroom, she was trying to be careful, but it was open and obvious. She knew about it. She had superior knowledge,
Right.
but it was her only aisle of escape.
Egress, yeah.
So that when you only have one way out, you can get around some of those other defenses.
Yeah.
It's an exception to the exception.
Yeah.
But outside of that, like you said, anything open and obvious when you're talking about, especially outside,
Yeah.
you know, a parking lot, you have many paths to travel. You don't have to shop there. You can move on. You know, then you're making the decision to take on that risk, and you are assuming that risk.
Right. And one of the ways in which lawyers, because we deal with these things all the time, is we can actually be pretty creative in the way in which we think about a particular situation. Like you said, like this parking lot was, you know, in disrepair. It was uneven. It was open and obvious to everybody that there were issues with that. All right. Well, there was a specific case in Charleston where that was the case. There was all these little holes all throughout the parking lot, right? But this person had never been there, and it had just rained. All the little potholes and all the little things had filled up with water. And this gentleman basically didn't know that he wasn't just stepping in another little, you know, millimeter, 2 millimeter, half an inch little hole, that he was stepping in a 6-inch hole in this parking lot, fell down, hit his head on the parking little bumper, and had a traumatic brain injury, right? And now, because of that was like a hidden hazard.
Sure.
They definitely knew about it because it had been there for years. We took pictures, and it had stuff growing in the hole. So if you have, you know, plants growing in the hole, it's been there a little while. Okay. And so that helps to prove that the person had constructive knowledge of the hazard and actually didn't fix it. And you know, if you can't know, if you're walking into a store, just how deep every puddle between your car and the entrance to that store, you know, is when you step in it. And so stuff like that, it can be, like you said, creative ways to sort of you know, find liability in very unusual situations. That's really how a lawyer can help.
One of my favorite ones that I've used quite a bit, and there's a lot of case law on it. Like I said, is optical illusions, and you say, well, how does that work? And that goes to creating the hazard. A lot of times, if you have a fall, and they say, well, what did you fall on? The floor is perfectly fine. Well, sometimes there's elevation changes that you can't appreciate because of an optical illusion, and sometimes it is the time of day when the light is shining on it. Sometimes it is just the way that it looks. A perfect example, and I told Richmond County about it, and they fixed it, was the new courthouse. The bottom step, if you haven't ever been there, the steps are, I don't know what you call them, Shawn, you may know, but they're gaps, they're
You can see through them.
There's it's a name of it, but I don't know the name of it. But at the very end, it looks like you're on the platform, and it's the same color as the actual floor. And I caught myself, like, I'm watching what I'm doing, and it still was.
You were expecting
tricky.
a further step,
right? And so I told them, and they painted did what they should have, and they painted it a different color, and now it's not a problem.
Right.
So there are different types of things like that, and I've had one in a salon where the floor was checkered pattern, big checks, probably foot wide type things. And there was a change in elevation that dropped down, but the checks...
It makes it impossible to see.
You can't
It's like camouflage.
And
Yeah.
so when you're walking and you're looking ahead, and in this case, it was a doctor's office, and the doctor is talking to the patient as they're walking, so they're making eye contact. They're not looking down. You're seeing it out of your peripheral vision, but it looks like it's flat. And the doctor had been there over and over and over again, so he knew to step down. There was no tape on the floor or any caution thing or saying step down or mat or whatever, and the person took a tumble. And that's where you say, well, there's not a hazard there. Well, yes, there is, because of the optical illusion. So that's, like I said, being creative, that's one of the ways. If there's not, like, a wet floor or oil on the ground or a hole in the ground, and you say, well, how did you fall? Well, that's the reason. Like I said, and I've had cases where you had the sun making an optical illusion. So it's a gray area, but there's ways to get around certain things in premise liability.
Well, and it's not even; these aren't even ways to get around.
Ways to get around
get around the law, but these are legitimate reasons and legitimate problems that need to be addressed that can cause people to suffer an injury.
Sure.
And most of them are just like the checkered pattern floor. Whoever put that floor in or decided that floor, that's what they wanted. That was for aesthetic reasons.
Right.
I have one that I'm interested in showing y'all. And I'll show y'all, and I want y'all to sort of point out to me what y'all find interesting about the videos and the particular clips, and let me know how you think
I would rule.
Yeah, how you would go about helping this person. So if you could go ahead and play the first video there, Genuine, and I would want you to pay attention to the gentleman in the very, very far back against the wall. Yeah, we got a staff member.
It looks like he's either sweeping or mopping.
Mopping the floor. Now he goes away, and what does he do?
Well, he's definitely not putting out any wet floor signs.
All right.
Walk through it.
Watch here. Oh, what did he grab? Where did he put it? Yes, he grabbed a wet floor sign that was on this right side over here, and he put it somewhere back there. Okay, let's go to the next one where they basically our people sit down. So entering the screen here at the bottom left-hand corner, you're going to see the plaintiffs sitting down at the restaurant. And the husband is going to go to the bathroom back there in that back corner. Now watch him. Watch the staff member go through there.
Pass the wet floor sign once again.
Now this is the person that falls. She's going to get up and actually go to the bathroom as well before they order food. All right. You see the path she takes? And there's the fall. All right. So
break it down for us, Shawnee.
Just for the viewers that, or excuse me, the listeners that don't have the opportunity to see this on video.
Yeah.
What we have, if you can imagine in your mind a T, like a hallway that leads to another hallway, and it tees off. And the wet floor sign where this individual was mopping, he's placed it to the right of that T. So someone walking towards that would not necessarily see the wet floor sign. That's when we watched the first couple of clips. I thought, oh, this person that's walking towards that T is going to slip where he was mopping because he can't see the wet floor sign yet. In that particular case, the girl goes into the bathroom another route, probably couldn't see the wet floor sign when she went to the bathroom. But then she comes out another route and goes past the wet floor sign. That particular case, you kind of have to think to yourself, how far am I supposed to be away from a wet floor sign before I can reasonably expect that the surface that I'm walking on is dry. So in cases like that, I think there's going to be some liability for the store, even if she saw a wet floor sign. A business, when they clean a store that's busy with patrons and walking through it, I think that they have a duty to clean the area that they were cleaning and to dry the area that they were cleaning. You can't just mop the entire place and leave quarter-inch of liquid on the floor everywhere and put one wet floor sign in the building and say, okay, we had a wet floor sign out. So in my opinion, the business has some liability for a fall. Obviously, it's not as, we talk about there's ranges of liabilities. There's comparative negligence. Yes, she traversed right past a wet floor sign before she fell. But the comparative negligence comes into it, but certainly they have some liability for her damages if she was injured in that fall.
Okay, good. Now, I'm going to change the scenario a little bit because what matters here are facts, right? And the jury gets to decide what the facts are and what the evidence is in the case. When you add evidence to the case, it changes the way the case actually comes out.
It can help or it can really hurt.
Right. So if you could bring back up the video, Genuine, of them sitting down. And I want to show you something. So this is after he's mopped. Okay. And I'm going to provide some additional facts here. So right here, this hallway right here is about 4 foot across. Okay. 4 feet. 12 inches times 4, right?
48.
There you go. Then you got that hallway back in the back. Well, we measured that. That's 3 feet.
36.
There we go. Then we have the sign, which is 10 inches wide. And both the husband that walks to the bathroom right here, go ahead and play it. Both the husband and the person that fell testified that sign was not in the aisle, that sign was against the wall, that he did not place it out like it was over here. Watch as he walks.
I was curious.
He's only got 3 feet to get through there. He's a big man. He does not move, check his pace,
gait,
go around it, go to the side. He's only got 3 feet, and he's got 10 inches.
I don't need to see any more.
There you go.
I don't need to see any more.
I just want to. It's an example of like how the facts in the case can really change everything.
What I would say is, that if the sign was perpendicular, then I would disagree with Shawn in that I don't think you got a case. But
I would totally agree with you based on those facts.
That's not what it was.
But and I was curious about that because you can't see the wet floor sign.
Right.
But if it's propped up, so you also have to think of what the wet floor sign says. It says wet floor and it has a man falling, right?
Yeah.
If that's not facing you, so they're walking left to right.
Right.
And if it's facing, front and back, you're not going to see it because you're not looking that way. So I think then you might as well not have a wet floor sign.
Yeah.
But I think if it's in front of you, then you have to. I think you lose that case. But with this one, if it's propped up, then I certainly think you have a case. And then it comes down to, does the jury believe the two plaintiffs that say that it wasn't propped up, that it was just leaning against the wall, we never saw it.
Right.
That kind of thing.
Right.
And just to give a little anecdote on, once Chace gave me those facts, I helped our good partner Victor with the case. I assisted him on, happened at we'll just call it a big box store, and they had used the cleaning machines that are almost like a Zamboni.
Yeah.
They drive around, clean everything, leaves water sometimes, and this individual had slipped on that.
Right.
And we have video footage. They got video down every single aisle, everything like that. And they're like, look, there's wet floor signs.
Right.
And no, if you walk down the aisle, every aisle, there's a wet floor sign at the corner of the aisle, and and it says a hazardous spill station, for. Yep. No, it's because they have them on every aisle in case a spill happens.
Right.
That's not a cone that is
set
saying
yeah.
there's a spill here,
right?
Type thing. So that's once Chace gave me those facts, that is very close to home and changes the entire thing.
And also on the first, before knowing anything about how the sign was set up, Another thing to think about, and this goes to, I agree with you on the first part before we knew, in that if you don't know how long it goes, right?
Mm-hmm.
So once you're in a situation,
Mm-hmm.
so once let's say the floor in this situation is 15 feet long, and the wet floor sign's in the middle, and once you're 10 feet into it, and then you see the wet floor sign,
Mm-hmm.
you can't go back. It's wet. You can't, if you go forward, it's wet.
Right.
So then if you're really careful and you still fall, then you can still recover, because it wasn't you're really supposed to have it at both ends so you can see before you traverse it.
Yeah.
Once you're in it,
Yeah.
once you're in a hazard,
You got to get out of it
you
somehow.
got to get out of it.
Yeah.
And so if you have think about it this way: if you have a huge hole
Mm-hmm.
and you have a sign that says "huge hole" at the end of it,
Right. Before you get there.
you're already in the hole.
Yeah.
Like,
if the bridge is out, but you put it
You're
on
on the
that
other
on one
side.
side of it, you still
It's
want to drive
too
off.
late. You can say, "Well, we put a sign up, but yeah, I flew
On
off
the other
bridge."
side,
Yeah.
yeah.
So there's all these little things, and that brings me to the point that we always talk about in premise liability is spoliation letters.
Mm-hmm.
What that means is you have to do it early, and what I mean early is the client has to come in early after the accident, because these videos that you see disappear, and without this video, your case is
Gone.
nothing. It's gone.
And let me tell you, the videos that are super, super helpful to a person that's injured, those ones disappear
Real fast.
super fast.
All the time.
Yeah.
All the time.
Yeah, the spoliation letters, for those of you who don't know out there, you can just think of the word spoil, and it kind of gives you an idea what is, the evidence disappears after some time, and the spoliation letter is there to let the premises know that they need to retain this evidence. And the effect that it has in Georgia and South Carolina is that if a person destroys that evidence, then it creates the presumption that whatever the person alleges was on there
Would have been harmful.
would have been harmful and would have been on there.
And it can be, you said destroy, and they a lot of times, I agree with you. I think they do it, but sometimes they just might,
Misplace it, yeah.
whatever. But it doesn't matter.
Yeah, there's
It
incompetence
doesn't matter.
everywhere, but
Right.
yeah, but
I know a certain grocery store, I'm not going to name it,
Okay.
that has purposefully destroyed evidence, and I've caught them numerous
Whoa.
times, and had them actually admit it. So just know that if you
it worked out
fall
for your client.
in
I'm
a
sure.
store, restaurant, or grocery store starts with a K, you might want to watch your P's and Q's.
Okay. Get to a lawyer quick if you fall, so you can send that spoliation letter.
Publix?
Publix, yes.
Never seen that place.
All right, we're gonna end on a practice tip
Oh,
today.
goodness.
Genuine, I have 2 little TikTok videos there. If you could just play the first one there for me.
Honor,
Yes,
at this time, the defense rests,
other than putting in our records. We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records. 2B, Nicholas Cruz Henderson, episode 1 record. Let me just stop. State, are you going to have anything ready for today?
No. We're
last told us
expecting,
there was 80 witnesses.
we're waiting for 40 more witnesses.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
so Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what? I don't want to hear it. I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend
you
myself.
can do that later. You can make your record later, but you've been insulting me the entire trial. So blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, This has been long overdue. So please be seated. You can receive the evidence. I will receive the evidence. And then you can put whatever you want on the record at the end. Go ahead.
That's what you call a bad day at the office for an attorney. Just to give you some context here, what this is this is the criminal judge in the Parkland shooting case. The guy's being tried for the Parkland shooting, and this is an example of how not to conduct a criminal trial. And in this case, what happened was that was the defense that came up and basically put two witnesses up and then entered in their records. And what they didn't do is actually confer with the other side, the prosecution, okay, about how long that they would take in presenting their case. That's important
and essentially
for a
alluded
lot of
to
reasons.
that it was going to be 80 witnesses.
Yeah, right. And then you saw the judge look to the prosecutor and said, are y'all gonna have any witnesses, here today? And they said, no, we've still got,
We're expecting 80
you're expecting 80 witnesses. We don't have our witnesses
We
here
haven't
today.
told them
right.
to be here.
Exactly. And so the judge is pretty pissed off that these lawyers didn't get together. Well, he's pissed off at the defense because apparently the defense kind of misled the prosecution here, and it is costing a bunch of taxpayers. So $2,500 a day to in the minimum.
Minimum.
That's just to have the jury assembled.
And the time.
Yeah,
The
all the
time of
judges,
people.
staff, all that stuff, right? And so they've completely wasted the day. So as a practice point for all these attorneys out there, talk to the other side. I don't care much you don't like them, whatever. Make sure that the case runs efficiently, because I'm going to go ahead and tell you that defense attorney is going to have a hard time with that judge the rest of her career. She ain't going to be doing another 22 years in that circuit, most likely.
Let me tell you, I would not want to have a hard time with that judge. I would like to please that judge, at any point, and hopefully have that benefit me in the future.
Yes.
There's strategic reasons that you could do something, to surprise with a witness that's on the witness list that you didn't intend to call necessarily, or not call a witness that you put on the witness list, but. In this case, it's not. Things. You're not putting down that I'm judge. We've got 20 witnesses to go tomorrow. We've got 20 witnesses to go the next day, and then when everyone shows up, say,
"We rest."
We rest.
Yeah, that's just it's
totally unprofessional, and
I'll tell you
no strategic advantage to it.
I'll tell you, my dad told me this, and I know my dad's if you've listened, I quote him quite often, but as crazy as he is, he'll be on the show one day and you'll be able to find for yourself. He's got some very good points, and he's always said it's kind of like baseball, and it's when you have a pitcher who's around the plate, who's throwing strikes all day, and he throws one that's just barely off the plate. Umpires are human, judges are human. They're more likely to go strike. Now, if you have a pitcher that's all over the place, right? He's up, down, left, right, can't hit the strike zone, and throws one just barely off the plate, umpires call him ball. Mm-hmm. And if you heard what the judge said at the end, this is a long time coming. Mm-hmm. You've been doing this, you've been doing that. This is unprofessional, and this has been coming.
Yeah.
So she hadn't been around the plate. The defense attorney has not been around the plate. She's been all over the place. Mm-hmm. So this is the judge saying, I've had enough. Mm-hmm. And if I think the judge she'd have still been mad, but would have been less mad and probably more understanding if the defense attorney had acted properly prior to that.
Yeah.
This was enough's enough. Enough's enough. Yeah. And so the practice point is, tell the truth, be honest, treat your judges fairly, try to be transparent on what's happening, and then if something does change, you go, I'm sorry, I didn't anticipate this. The judge is going to be more understanding. But if you're trying to fool people and play tricks,
right,
and then you throw something like this,
yeah, she said they were not there at 9:15. That information that they were going to be done by 11:30 should have been done at 9 a.m. if they knew it then.
Absolutely. There is cases where, some things, are client driven.
Absolutely.
Clients make a lot of decisions in cases, and sometimes things change. You show up, I have a client that says, by God, I'm testifying tomorrow, even though it might be against my advice. I'm testifying in the morning. We're starting our case, and then I try and advise him against it. He says, no, I'm telling my story. And I say, okay, I let the judge, the prosecutor know this is what we're starting with. We show up in the morning. Shawn, I don't think that's a good idea for me to testify.
Right.
Yes, sir, I told you that.
Yep.
You know, and then, but right when court starts, or even before court starts, I get with the prosecutor. I talk to the judge, you know, in chambers and say, hey, change of plans. This was unexpected, but this is where we're moving towards. You know, it's just a level of professionalism that works out to your benefit with the other side, defense attorney or prosecutor, or, you know, defense attorney for a civil case, and works out better for you with the judge, just being transparent, being honest, and trying to work the most efficiently way to get justice for everybody.
Yep. And like you said, that case that, you know, if you have that happen, your history, not only in that case, but in prior cases, also helps you. That you've done the right thing, and that you were prepared, and you tried your best to do things in the correct order. And if it doesn't happen that way, then they go, okay, well that's uncommon.
That's an outlier.
That's an outlier. Mm-hmm. But this situation, it seems like that is the rule,
norm,
not the exception.
Yeah.
So you don't want to do that.
No. No. Avoid that at all costs. Well, thank y'all very much for listening, for watching. I hope you learned something today, and we look forward to talking to you next time.